Hello, my name is Jeffrey Tetso. I'm one of the attorneys in-house with the law office of Brian Fagan. And I'd like to talk to you today about one of the most important things that we see here at the office, and that is custody issues. I want to go over some do's and don'ts. It'll help you a great deal in dealing with custody matters. And we're going to start right off with the main issue of what is in the child's best interest. And how does a judge or a mediator make that decision when it's contested? So, what we want to do is present the most stable, healthy environment for the child or children in question to put you in the best light to be the party chosen to retain custody of their child. And that is something that judges always want: stability, a healthy environment, and proof that you can provide that or have been providing that. In addition to that, as far as recent history, we want to talk about what has been going on in the last 6 months, maybe a year. If you go further back than that, then you're kind of getting into things that aren't right up to date. So, who has been the primary provider for the child in the recent past? And hopefully, that is your client. We're representing you, because if not, you're looking to change the status quo, and you're going to have to put on some evidence as to why there needs to be a change for that child to have a better, healthier environment with you as the primary custodial parent. Now, when you look at this, you want to bring out any negatives that the opposition has in their past. We're talking about criminal issues. We're talking about any kind of drug dependencies. We're talking about mental or psychiatric illnesses that a party may have exhibited over the past. This can go back more than just 1 year. And a client's knowledge of this does not have to be backed up by a medical expert. You can easily testify in your hearing as to the opposing side's instability. Again, their dependency issues, things that they haven't resolved, that they may have avoided getting treatment for, and that definitely looks at their fitness as a parent to be able to provide the healthy environment for the child or children. Um, you also want to show that you, as the party wanting primary custody, already has a home ready for the child, and that they have their living space, their own bed, that there's no big change to the child, and that you're not even there with the space needed to the child have their privacy. Things like that are always going to go in your favor. Now, along with the residence, the area where you're providing for the child or children, is who lives there. If there are any people who live in that same household or frequent that household who are in any way unhealthy, have bad habits, have criminal issues, any kind of background of violence, drinking, unhealthy lifestyles, then you obviously bring that up. That's extremely relevant to the custody issue, because that healthy environment is going to be threatened by these characters. And oftentimes in a family, there's one or two of these people that continues to be in the household, and that would be something that you would obviously have your attorney bring forward in the case. Uh, One of the things you have to be ready to deal with is exaggerated claims from the other side. They're going to take an incident that happened 3, 4 months ago and blow it completely out of proportion and make you look like somebody who is unstable and can't control yourself and can in some way endanger your child or children's well-being. You have to be ready for this, because unfortunately, that's the nature of a custody issue. It becomes very emotional. People do things out of spite, and they take whatever they can do to make you look bad. So you will prepare for that and be ready specifically to testify what really happened on that occasion. You present the actual facts and counter that issue so that it does not become an impediment to you getting a favorable custody ruling. Now, in addition to this, when you are getting ready for custody with your attorney, it always helps to keep a diary. If you keep dates, times, and incidences, literally quoting language that's going on between you and the opponent, then you have the ability in court to testify as to specific issues and counter, again, their vague recollections of trying to make you look like the unstable parent. So you, by having a diary, can say not only is that not true, but you can testify as to the specific conversations, things that the other side may have mentioned that would show an indifference for the welfare and the child's emotional, mental, or physical well-being. These are things that will score huge points in your credibility with the judge or the mediator. As we said, you want to convey that you're the primary provider for the child's daily routines and have been. This is involvement in school activities, the child or children's teachers. You should have a good relationship there, along with a record of all doctor visits and any health matters that you have provided for the child or children. If you can demonstrate this, you're showing the mediator or the judge that you are the parent who's been dealing with the child's best health and welfare, and that means the other side is letting you do all the heavy lifting in the parenting game. Now, one thing I want to make very clear, this is something that many clients think is the way it goes with child wanting to testify as to who they want to live with as their parent. According to Texas Family Code 153.009, upon the motion of any party to a custody action, a judge must interview a child who is 12 years or older in chambers as to what that child feels is their choice of a parent. But this is not a determining factor by itself. The entire custody case is going to be what the mediator or judge makes their ultimate decision on. So don't think that because the other parent is threatening to say, oh, the child's going to tell the judge he wants to live with me, that doesn't necessarily carry the day. And I would say, as a matter of course, that a 12-year-old's testimony in chambers is not quite as convincing to a judge as maybe a 16 or 17-year-old teenager, because at that point they've seen it all and they have a little bit more awareness of what's in their own best interests. The age of any child or children in the case is case sensitive. The age of the parents is telling. Younger parents have less experience dealing with all of life's ups and downs and parenting skills. So anything that affects other siblings in the household is relevant. Why would you want to take one sibling away from their brothers and sisters unless it's absolutely necessary? So you and your attorney will discuss that and try to maintain the family unit as stable as you can in a custody matter. Now I'm going to just hit a few don'ts. These are my personal favorites on what will not help your case. Don't be uncooperative and constantly trying to undermine and badmouth the other parent, especially in front of your child or children. That shows immaturity. It shows you're trying to manipulate and kind of play games with your children's thoughts and how they perceive things. It's just not good, and judges will see that that's an immature parent who really has their own issues to deal with. Number two, don't come to court unable to explain your parenting plan or the stable environment that you have already set for the child or children in the case. That's going to show that you're not truly the prepared parent in the custody issue. And don't let your hasty emotional decisions play into the custody game, because if you fall victim to that, you can be sure the other party is going to jump on it and try to make that look like you're unstable. You can't control yourself. And that, again, is just emotions that come with the situations. Don't come to a hearing and be unaware of your child's school and academic progress and how you're helping the child with their schoolwork and you're active with parent-teacher activities. That's a big factor. And one thing I'd like to kind of on today is I personally believe it's never good to ask your child to say who do they want to live with, especially for a younger child. Now, if we're talking teenagers, that's a different story. But in my personal opinion, you ask a child under 10 years old what parent they want to live with, you put that pressure on that child, to me, that's almost emotional abuse in and of itself. So don't ever do that to your child, because that's something for parents and adults to determine what's in the child's best interest. the child shouldn't ever be put in that compromising situation. It's just not fair to them, and you always want to do what's in the best interest of your child for any custody case. Well, I hope this is helpful. At the Law Office of Brian Fagan, we enjoy helping guide you through the many issues in family law cases, and custody are the most delicate of all. It's been a pleasure talking to you.